The Queensland government is seeking to change the law that prevents a person charged with serious sexual offences from being named until they are committed to stand trial. This law has been criticised for creating an imbalance in the criminal justice system and for allowing accused rapists to continue their lives under protection while their alleged victims suffer in silence. One of the cases that could be affected by this law change is that of a high-profile man who is facing 2 counts of raping a young woman in Toowoomba last year. His identity has been kept secret by the court, but that could change if the new laws are passed and come into effect later this year. The media companies have tried to challenge the court order that bans them from naming the accused man, but their bid was rejected in February as premature. The committal proceedings for the case are still ongoing and the next hearing is scheduled for June 28. The accused man remains on bail and his lawyers are seeking access to information from his alleged victim's phone. The new laws are expected to be introduced into the Queensland Parliament this week and passed in August or September. They are based on one of the 188 recommendations from the state's Women's Safety and Justice Task Force, which was set up to overhaul the sexual violence laws and address the low reporting and conviction rates for these crimes. The task force also recommended adopting an affirmative consent model, which requires a person participating in a sexual act to actively seek consent from the other person, and not assume it has been given. This would bring Queensland in line with other states like New South Wales and Victoria, which have already passed similar laws. Another reform that the task force proposed is to criminalize stealthing, which is when a partner secretly removes a condom during sex, without the other person's consent.